welcome to BW Legal World. Today we have with us Mr. Sridhar Potaraju, Senior Advocate at the Supreme Court of India. Mr. Raju, I would like to ask you about the difficulty in obtaining bail in today's scenario. How do you think the courts, while not granting bail, are affecting the criminal justice delivery system?
See, it's a very complex issue for the court because the court is not looking at the accused alone, but it's looking at crime in society. So therefore, a message needs to be sent that crime will not go unpunished and there will be a consequence which shall be severe. So that is the message the courts as a constitutional responsibility are actually undertaking. So they balance the rights of the accused along with the rights of the victim and the larger interest of the society to keep it crime-free. So that's a difficult balance. For a person on street, I mean, a given order could look good or bad, but as an institution, there are larger considerations of balancing the diverse competing interests of all the stakeholders and to ensure that the society remains broadly law-abiding, and then also a fear of law is there in the society, which is very important for any rule of law democracy.
Sir, a lot of cacophony has been brewing in the legal corridors about allocation of cases to particular benches and predetermined outcomes. What do you have to say about this? And do you think the power of master of roster needs to undergo some change?
I feel there is a set of practitioners as activists whose end goal is probably to pull down anything which is functioning well, because they don't have any positive end goals, as you see. I mean, I've been practicing for more than 25 years, and one thing is very clear. I mean, ultimately, the role of every institution in a constitutional democracy is to perform in terms of the rules and the laws applicable. See, the master of roster is the law of the land and affirmed by multiple judgments of the Constitution Bench of the Supreme Court. Now, this infinite regression of the regressed minds to question everything which goes the way they don't want it to go or not going the way they want it to go, you find the same chorus coming from the same set of people. So if you can just draw a pattern, you'll find the same people complaining every time an order goes against them, and they go into deep silence when the orders are not actually what probably the other side would want, but are in favor of their chosen clients or the causes or the ideologies they propagate. As a practitioner, I believe the institution and the people who man the institution have to be respected because they have constraints of the decorum and the dignity of the institution in mind, and they will not be in a position to come back to explain on a private YouTube channel or probably on a TV debate. So we need to give that due to the honorable judges who are actually delivering justice in very, very trying and extremely challenging society which is driven by social media.
So there has been a witnessing change in the way PILs are being utilized by certain individuals and certain groups and being styled as publicity interest litigations. Do you think the courts need to put their foot down?
I think the courts have now seen through this anarchy interest litigations, because the purpose of litigation is only to destabilize. Unfortunately, certain groups which are ideologically rooted do not believe in democracy or probably rule of law, but they very well have trained themselves to use the democratic institutions to demean or destroy constitutional rule of law. I think the courts have now are alive to these kind of attempts, and oral observations are being made, and also judgments have actually recorded certain set of petitions to be driven by ulterior or oblique motives. So the courts are now very much alive about it, and there is obviously in every society you have all kinds of people, and there is this kind of groups which are unable to persuade the larger polity in a democratic election to persuade to their views. They used to find the courts as a shortcut to get their agendas worked out. The courts have taken up causes which were legitimately within the four corners of the Constitution, but have definitely put their foot down when they realize that the courts have been used only to bypass the democratic process and then to get orders without any accountability before the public, who are the primary stakeholders.
Thank you very much, sir. Lovely talking to you.